Not filled to the rafters today. All right. So, folks, we have 4.5 hours of argument time with this small group here. They have a lot to say, I guess. So that said, you know the usual speech. I'm not going to say it, that we've read everything. The clock's for you, not for us. So that said, People versus Clarence Ross. Well, that's submitted. Second case, 622 3rd Avenue versus Hyatt Leader. Anybody else? Going once, going twice? Do you want to submit? 6 minutes is a long time for one person. 5 minutes is a long time. You're not going down? How about give you 3 minutes, okay? And you're the appellate, correct? All right, 3 minutes. It's hard to argue against yourself. Be careful. Third case, Brian P. versus Tanya C. Submitted. 769 East LLC versus Ofori. Submitted. Ooh, was this something I said? Houston versus Regis High School. Who are you? How much time do you want? 15. Okay. Oh, so I'll give you 5 and 3, and you'll get 5. Okay, thank you. Let me get this is the Treewell case. This is the Christmas tree case, right? Okay, yeah, all right. I got it. Thank you. People versus Dwayne Gibson.
2 minutes, Your Honor.
Oh, you're by yourself. 2 minutes. Here we go. Oh, I'm sorry. 2 and 2. Thank you. Number 7, Board of Managers versus McGowan. No appellant. You want to submit? 1 minute. That's just get your appearance out. That's a minute. I'll give you 2. I'll give you 2, yeah, because 1 minute is just getting your appearances out. You're done. 2 minutes. Number 8, Friedco versus Friedco Capital versus Park Rio. 5 and 5. Here we go. Thank you. Rizzo versus Romero.
6 minutes.
All right, 6 and 3 and 6. Thank you. People versus Felix Urbistando. Submitted. Case number 11, a matter of Conrad Buckle. Yes, sir. You want to argue your case or no? I don't. It's a submit. It's a submit. Okay. Oh, I didn't see that. I'm sorry. That's why I have wing people. Gorin versus 72A Realty Associates.
7 and 3, please.
7 and 3. Okay, 7, 3, and 7. All right. 13 and 14, Mayville Engineering versus Peloton Interactive.
Your Honor, appellant requests 10 and 2.
I'll give you both 6 and 3, 6 and 3, and remember the clock's for you, not for us. So there we go. Thank you very much. First case up is 3rd Avenue, 622 3rd Avenue, Hyatt versus Hyatt Leader.
Good afternoon, Your Honors. May it please the court, my name is Stephen Kaplan, and I am appearing for the appellant Hyatt Leader. There's been no opposition filed to our appeals, which is why I'm here by myself today. Your Honors, we believe that this case represents a improvident granting of summary judgment against my client, but by virtue of the court not really focusing on what the relevant documents said, and focusing instead on peripheral matters which did not undercut our claim. The sequence here is really important, and which is why we think the court below erred. This is, as I say, a COVID-era rental dispute where my client, due to the emergency regulations, vacated its premises, fell behind during that after it vacated in its rent, and was presented with a rent demand, which gave it two explicit options. The options were that he could maintain possession of the premises by paying the rent, or it could vacate the premises. There was no reservation of rights, nothing in there which said you have to.
Wasn't there a time by which that the premises had to be surrendered in the rent demand, specifically October 15th, 2020?
There was, Judge, and I mean, there are lots of reasons why the response was late, none of which I think are, the mail wasn't getting to them. Turns out that the person the mail was sent to had COVID and actually died a few weeks later. But no one, when they responded to our acceptance of the demand, no one raised the fact that our vacating the premises was late.
I mean, well, it was late, but wasn't there a letter on December 2nd, 2020, which specifically said that the acceptance of the keys did not take away the rights to do anything else?
There was,
pursue
Judge.
any other rights? So, landlord hereby accepts the tenant's surrender of possession only without prejudice to and expressly reserving landlord's right to seek damages arising from the tenant's breach of lease. So they kind of reserve their rights.
Well,
I mean, I get
They
that.
didn't, and I'll explain to you why, because this is what the judge below didn't focus on, is there's a sequence of events. There's a rent demand, no reservation of rights. There is, on November 18th, an absolute acceptance of that, a surrender of possession, a surrender of the keys. We're out of the premises, we gave back the keys. And then, after offer and acceptance, for the first time on December 2nd, they say, okay, we
So, counsel,
accept
may I
it.
interrupt you? When you say offer and acceptance, what was the offer? The offer was you surrender by this date. Did you surrender by that date?
We did not,
So
Judge.
then there's no acceptance.
But Judge,
So that's done, right? If you say offer and acceptance, you have to accept the offer that was made, and you just said we did not. So then move on to the next thing. What happens next?
well, okay, so Judge, we get late notice because of COVID, but we do accept it November 18th. We transfer title, we transfer the keys, we give up.
And the November 18th notice says we are reserving our rights to go to seek unpaid rent.
That's 2 weeks later from the landlord.
Right.
But they say, we accept your surrender.
Yeah, but the bottom line is, as my colleague points out, you blew the first one. If you had done what they told you the first time around, you wouldn't be standing here right now.
I agree,
We
Judge.
got everything. Thank you very much. Thank you.
Okay, thank you, Your Honor.
Next case, 769 East LLC versus Afori.
That was submitted.
Houston versus Regis High School. I'm just, my second cup of coffee, that's what happened.
That helps.
Thank you. Okay, go ahead, counsel.
Good afternoon. May it please the court. My name is Joseph Kim. I'm appearing here for the defendant appellant Regis High School. And this case, as Your Honor appears to be aware, involves a trip and fall on a pile of Christmas trees that was laid on the curb behind the premises of Regis High School on East 85th Street between Madison and Park.
So why don't you think there's a factual issue here? Because we saw, I know all my colleagues looked at the video. It's pretty clear. If one video has Regis employees dumping all the Christmas trees out onto the sidewalk, we have the co-defendant admittedly during the argument before the court saying, yeah, the co-defendant being the next door building, we also tossed out Christmas trees onto that pile too. If you watch the video, she tripped on the trees because she put her cell phone back in her pocket. She's walking and she had to sort of move closer to the trees because there was a carriage with 4 kids coming at her. So, the sidewalk is kind of narrow by the extending trees, right? So why isn't that a factual issue as to liability there?
Yes, Your Honor. There is a case that's exactly on point from the First
Really?
Department.
Name the case.
Leung versus Madison Street Partners, LLC, 203 83rd 578, a 2022 case affirming the lower court's grant of summary judgment for the defendant.
What's that site again? The site again, please?
203 AD 3rd 578.
Okay, got it.
And in that case, which I believe Justice Scarpula actually sat on that panel,
No, that was a different case. Judge Owen was on that too. That case was completely different. In fact, there are Christmas tree cases in which summary judgment was denied, right?
that is correct, Your Honor. There were
The case that you're talking about is something completely different. It's garbage, and it was garbage bags. There were red ties. The garbage was exactly where it was supposed to be. I'm here to tell you, I know what you're talking about. Don't think it's the same, but I appreciate that you raised it.
I agree, Your Honor, that that case involved garbage bags as opposed to Christmas trees.
Judge Owen was on that case too, I think, right?
I don't remember what I had for dinner last night, but okay, if you say so, then I agree with you.
But in 2013, we had the Nunez case, which was also where summary judgment was denied because there were triable issues of fact as to whether the large spreading Christmas trees on which plaintiff tripped was an open and obvious and not inherently dangerous condition. So how is that not, I mean, isn't that really a question that we usually use for the, reserved for the jury as to whether or not it was open and obvious and not inherently dangerous?
Yes, Judge Kapnick, and to actually delve into the facts of Nunez, I had to go into the appellate briefing because it wasn't really stated in the opinion itself. But the issue there, and the test which is consistently applied in all of these cases, whether they're Christmas trees or garbage bags, is whether through the reasonable use of one's senses, you could have avoided the danger.
Open and obvious usually end up being an issue of fact. Of course, it becomes a matter of comparative negligence, and it's an issue which goes to the jury.
Yes, Your Honor. But if I could finish my answer to why Nunez is distinguished, it is that when you use your senses reasonably, but you still cannot avoid the danger, which is what happened in Nunez because the plaintiff there argued that her view of the trees was obstructed by other pedestrians and other garbage bags. But here we have the plaintiff admitting that there was no obstruction, that she saw the trees as she approached. We have the
Yeah,
video.
she saw the trees, and she had to get closer to the trees because it was the passageway was narrowed by the trees, and she gave way, or she saw the carriage in the city of New York. You can get these strollers; they're gigantic, right? Take up most of the sidewalk, so she had to move closer to the trees, and she still, she still walked, and she's entitled to walk, and she tripped. And that other case that you mentioned, I'm looking at it right now. Wonderful items here. It says right here that there was ample room on the sidewalk for plaintiff to have avoided the bags had he so chosen. Well, in my view of the video, I didn't see any ample room, or at least that's a factual issue, whether or not the narrow path that was provided after the trees were put down, was that going to be sufficient for her to walk through? That's a fact issue.
Yes, Your Honor, I'm glad you brought up Lung again. I did want to go back to that because that opinion also states that other pedestrians were using the walkway, just as it was the case
Yeah,
here.
but the key fact is that there's a factual issue, at least in my mind, whether or not there was sufficient space for everybody to walk through.
Well, that's exactly the standard that is not applied here. And there's a case called Ruiz versus 221.
Okay, you know what? If you think about some more, you'll get rebuttal time, so I want to hear what the other side has to say. Thank you.
Thank you.
May it please the court, Adam White, representing the plaintiff respondent, Barbara Hudson. As your honors have noted, normally this, when it comes to open and obvious.
What was wrong about the way they put out the trees?
At a minimum, it was a haphazard pile. The trees covered more than 2/3.
Neatly piled at
What began?
the curb.
What began, Your Honor, as a neat pile subsequently turned into a haphazard pile. Or we can use semantics, a pile of trees that obstructed approximately 2/3 of the navigable space.
Isn't what happened here is you look at the video, she's on the phone, plaintiff's on the phone, and she finishes a conversation, and she's putting her phone away. There's the stroller coming by, and she seems focused on the stroller, and therefore just gets nicked by the edge of the trees.
I believe the sequence is a little off, but your honors is accurate. That's what happened. The fact is, if you look closely, as Judge Hagler did, he mentioned it on the record, he looked at this video 5 and 6 times. I imagine your honors looked at it several times as well. Because each time you look at it, you see more information, as I did. Number one is, you notice that she did enter, arguably, inarguably, entered the space, that navigable passageway, before this group of 5, 3 kids, a stroller, a caregiver.
Well, I mean, I don't know if that is a fair and accurate, because the placement of where the people were as in, I guess, relation to where the accident happened, it was not towards the end of the trees, it was further towards where she had just started entering the trees. But my question really is, your adversary makes a big deal about this one case where the garbage bags were placed on the side of the road, and the side of the curb, and then she, in that particular case, there was an accident maybe similar to what happened here, you know, if you're familiar with the case. Is there anything that, about the trees in this case and the branches that might have been protruding that maybe distinguishes that just a little bit?
Sure. I think you're speaking, I recall, is the Bisogno case, and that is the, I believe it's Bisogno. Which,
No, I'm talking about the case that your adversary referenced here today.
Oh, you know, it's funny. I didn't notice that case. It was interesting. That was the first case I didn't
The
notice.
Young case, right.
Yeah, I'll look at it when we get back. But so I can't really speak to that case. But the other garbage bag case, I remember there was that there was a trip and there was a slip on wet substance. That was the only garbage bag case that I saw cited in the briefs. You know, it's interesting because a couple of things that of note are that she did wait. She put the phone back in her pocket. She did. There was evidence, indications that she did wait, and then she proceeded. And then, like I said, arguably, who's in that space? In the narrow, hazardous space, where the subtle, latent, hazardous condition existed, which was the tree branch that was extending, that was low-lying, and there's case law that says when a condition is low-lying and through the reasonable use of one's senses, not readily apparent, particularly if the plaintiff is distracted by the oncoming pedestrian traffic. And I'd like to cite, there's ample case law, as your honors have mentioned, the Christmas trees that said, you know, even if it's a large spreading Christmas trees, open and obvious, and whether it's not inherently dangerous or normally issues of fact. But there's a recent case decided by the Second Department, which is Butler against Winthrop Hospital, 2024, handed down March 13th, in which they mentioned, they state, when a person's reasonable use of their senses may be rendered a trap for the unwary where the condition is obscured or the plaintiff is distracted. So the fact that she's entering the space and then she sees these people coming.
What in your view did the defendants need to do here that they failed to do?
They need, according to the sanitation rules, Your Honor, they needed to neatly place the trees along the curb, not covering 2/3 of the sidewalk. That's what the rules, the sanitation rules require. There's also administrative code that requires property owners not to unreasonably obstruct the sidewalk and keep it in a reasonably safe condition.
So you say it's an issue of fact as to whether it was reasonable, what they did, what she did?
Absolutely, and anything that she did or didn't do, it goes to comparative fault. It shouldn't, if this court were to decide, it would really eviscerate a lot of this court's precedents, and then leave property owners just to drop Christmas trees anywhere. It's always open and obvious. You come in contact with them, it's an assumption of risk situation.
Okay, thank you.
Thank you.
Your Honor, I'll be very brief. Ms. Hudson understood the danger. She testified that she stood off to the side when she was taking her phone call, and she saw the strollers of other people coming, and she knew not to walk then because of the danger. That's on appendix page 187. I'm going to quote her. I remember waiting for some people to go past them because I couldn't even
But
get.
she's, I mean, but are you saying, so she was required, I mean, we all watched the video, as you know, so is she supposed to wait, and then if she sees somebody back up and leave again? I mean, there was a lot of pedestrian traffic along that 85th Street during that period of time, and several people with strollers. That was not an uncommon
I
thing
agree,
on
Your
the
Honor. It was a
video.
very fluid situation, but then she steps up and sees the biggest group of all. A woman with a stroller, 3 children around.
Yeah, that stroller takes up all that space. But like as my colleague points out, that goes to comparative fault. Should she have waited? Should she have backed up? I mean, there's a lot of moving parts here. I got one curious thing is your next door neighbor, during our argument, pretty much conceded, yeah, we threw Christmas trees on that pile too. The thing is, in my mind, it's like, okay, whose trees are these then, right? At this point, did it trip on your tree or did it trip on their tree? And you have video. Why isn't there any video footage going back like when the trees were even being tossed out? Because you got video of the school's employees putting the trees out.
Well, Your Honor, for the purposes of this appeal,
I was just curious.
it's not relevant to us pointing fingers at each other saying it's your tree or my tree. We're just going to treat them as one pile of trees.
Okay, fair enough.
And
And yet, you don't deny that the way that you put the trees, the fact is, it is not the law that you can simply make an unsafe situation, and because someone can see it, therefore you could never have liability. That seems to be what you're arguing. You're not denying that those trees were strewn all over the place. That's different from an open and obvious condition, like a stair or something else. That's your creation. You're not entitled to create a dangerous condition and then deny liability because somebody could see it. That's the whole point.
Your Honor, it is not our position that it was just strewn any which way. Or that
Okay,
it was
so
dangerous.
we'll
And our
change that. We
position
all viewed the video and saw the trees strewn over 3/4 of the sidewalk.
Our position is that the video is actually proof in our favor because it shows that groups even larger than the plaintiff herself were able to safely walk that
How
sidewalk.
do you address the fact that you created that hazard?
I deny that it's a hazard, Your Honor, because the
You
video
don't
shows.
think trees, Christmas trees, strewn all over the street could be considered a hazard?
That's not what the video shows you.
Okay, well then I
Okay.
guess we disagree.
Thank you.
Thank you.
People versus Dwayne Gibson.
Good afternoon, Your Honors. My name is Stephen Burko, and I represent Appellant Dwayne Gibson on behalf of the Legal Aid Society. I'm here to take any questions from the court. If there are none, I'll rest on my brief.
Any questions? No? Okay, thank you, counsel.
Beth Cublin for the Bronx District Attorney's Office. Good afternoon, and may it please the court. Do Your Honors have any questions for me?
Nope. Any questions? Nope. Thank you.
Okay, the people request an affirmance. Thank you.
Board of Managers versus McGowan.
Good afternoon, Your Honors. Kelly Ringston, Braverman Greenspun for the respondents. May it please the court, I asked for a single minute extended to 2, just to draw the court's attention to page 154 of the record, which explicitly contradicts certain allegations made in the appellant's reply brief, specifically that he did not execute the guarantee that is at issue here. So if Your Honors will refer to the record 154, paragraph 12 is the affidavit of the appellant confirming that he in fact signed the guarantee. That's all I have, Your Honors.
Right, thank you.
Thank you.
Frico Capital versus Park Rio.
Good afternoon, Your Honors. Adam Sherman, Jacobs PC for the appellant. This is an appeal from the lower court's denial of a CPLR 3213 motion for summary judgment in lieu of a complaint seeking to enforce an unconditional, absolute promissory note. The lower court denied the motion on 2 grounds, both of which were in error. The first ground for denial was that
I guess you thought that it wasn't a 3213 because there was some sort of operating agreement or some sort of other venture that the parties were involved with, and that sort of took away from the nature of it being a true 3213 motion. I mean, I think that's what
the lower
ultimately
court.
she was getting at.
That's correct, Your Honor, but the error in that is, in order for that to be true, if there's a dispute pursuant to a contract that's separate from the note, under the case law, the only way that that could stop a enforcement of an unconditional promissory note if the note itself refers to that other agreement such that the performance of the two are intertwined.
And in the 2019 note, there was no mention of the South Side project, was there?
Correct, that's absolutely right. So it's, there may be a dispute as to a distribution from that company, but that is completely immaterial on an unconditional promissory note that waives all defenses except payment.
And that's what I was going to say. Doesn't the language of your promissory note involved in this case, as most promissory notes, specifically waive any defense, any set-off, any counter?
Absolutely, Your Honor, yes. And I just want to note that the lower court was of the opinion that they asserted the defense of payment, but that's just not true.
Yeah, I'm glad you meant, because that was one of my questions. I think the lower court gave me the impression that it was concerned that you were double dipping, that you were going to collect on this promissory note and then also get money from
Your
the
Honor's
other
correct about that suggestion, but the evidence just doesn't show that. And case in point, there's no evidence that the defendants paid the plaintiff anything.
I thought your answer was going to be, it doesn't really matter, Judge, if we were double dipping. I got my promissory on one side, I got the other side. It is what it is.
That frankly, that is true also, but the important point is if they were to assert the defense of payment, they would have to show that they paid money to the plaintiff, and they can't show that because at best, they can show that they're entitled to a distribution from another company, and that's waived under the promissory note's terms. The second point of contention from the lower court was that there's a dispute about a 5% late charge. As a threshold issue, that doesn't stop enforcement of an unconditional promissory note.
Always figure out the amount of damages.
That's exactly right. And the second point is that a 5% late charge is simply courts routinely enforce those. So there's no material issue of fact on a 3213 to enforce a unconditional promissory note.
Okay, thank you.
Thank you.
Thank you, Your Honors. May it please the court. I'm Tom Mullaney from the law offices of Thomas M. Mullaney for the respondents.
The settlement from the other litigation was meant to pay you off your obligation on this note. Why didn't you get something stating that the note is paid off with that litigation?
Well, there was a disagreement about that. So what was in
That's
appellant's
your
own.
defense to this, isn't it?
Yeah, yes, Your Honor. But what appellant put in its demand letter, it's and notice of default, which is totally elective. It says we took this money that you would have otherwise had, and we have paid it for other purposes not related to this note. So there's a disagreement about that. So that my client couldn't get a signature saying, "Hey, that's what this money was for." There's a dispute about it. Now we
Then
would.
you face the fact that the note says that there are not supposed to be any set-offs. So you start out with the note being against you.
That's
Besides the note's against you, but it also precludes what you're trying to say here.
I don't think that's true, Your Honor, and I'll say why. Because I think we're arguing payment, not set-off, not some other debt from somewhere. We're saying that the money went from
It is
South
exactly.
Side
Let
to
me
Friedco.
interrupt you.
That's
How
right.
how could it not be a set off? It is a payment that you get for a totally unrelated deal that you want to use to satisfy this. That's exactly what a set off is. If you look at the Black's Law Dictionary, that's the definition of set off. And so what you would need to do is show a check that you paid this note. You didn't do that. You said, no, there's another deal that we had where we're supposed to get paid to the deal. That is exactly what a set-off is.
Well, I say it's payment, Your Honor. I realize it's
Does the money from that deal have anything to do with this deal?
Yes,
No. Payment, you're saying. I'm saying the money that you got from that deal, is it connected in any way to the money you owe in this separate deal?
yes.
How?
Appellant wrote the notice of default, final accounting, and smushed them all together. We didn't do that. Appellant did that.
Again, is that money that you got from a separate deal in any way connected to the money that you were supposed, or whatever you were supposed to get in this deal?
Appellant connected them. If appellant hadn't, I'll put it this way, Your Honor, if appellant hadn't written that notice of default the way it was written, agglomerating all of these things, that would be a different case, and I would be saying no to Your Honor. But that's not what happened.
Okay.
And I would also say that doesn't consider the $125,000 separate from the money that went for the Southside deal. There's no explanation why that was taken. Mr. Friedko took that.
You're talking about the extra money for the other deal or for this deal?
Extra money for the other alleged deal.
That other deal is a different deal. So again, you may argue
Yeah.
in a lawsuit about that deal, but this is an instrument for the payment of money only, in which you have agreed that the only thing that you can show is a check for payment.
Why is it, Your Honor, that the appellant can base its notice of default on assertions of fact which we dispute, and we cannot challenge them in discovery in that case?
Are you challenging that you didn't pay this note off directly?
That's correct.
Directly?
That's correct. That's exactly what is being challenged. It's an R40 of the record. There's an extended discussion by Mr. O'Reilly, Riley, not O'Reilly, of the payment.
I think
Right, but I think that the issue is that what you're saying is proof that it was repaid relates to monies that came from a different deal, and there's really no direct link other than this testimony that would say that this was repayment for the promissory note.
The appellant plainly makes it a direct link. It's in the notice of default.
Counsel,
It
you
wouldn't
know-
be a default if those things didn't happen.
I just heard what you just said, and this goes
Yes.
back to what Justice Kapnick said. This is a lot, if we were to agree with the appellant here, it would just be it would be just on liability, and you could go back on damages, exactly what you're saying, that we paid off everything, and that's something you can prove below, right? I mean, if we were to agree with them. I mean, that's what you're saying.
That's a different issue, Your Honor. I don't think that's up on.
You just say you paid off the loan.
That's correct. But should it go back for a question of whether they have the ability to show that we paid off the loan in liability, or should it be damages? I don't know. That's not, as far as I know, that's not present for.
All right,
But
thanks
you're
very
correct,
much.
Your Honor. If
Thank
you send it back for liability.
I don't know, I mean, I'm just saying, if I were
Yeah,
to
it's
agree
the
with
same.
them, right? Okay.
I agree.
Thank
Thank
you.
you, Your Honor.
Rizzo versus Romero.
Good afternoon, Your Honors. Christopher Clark for the plaintiff's appellants. Your Honors, when the lower court dismissed the appellant's complaint with prejudice on a pre-answer motion to dismiss, it committed fundamental error in misinterpreting the law of adverse possession with respect to co-tenants. Thereafter, it compounded its error and used the same flawed logic to do a statute of limitations and laches analysis that was incorrect because the court misperceived the case law and the rule on ouster. Not only was this holding incorrect, but
So the Romeros get title in 2004, right?
correct, Your Honor.
So where are your clients for all those years?
They are not in possession of the property at that point. They are merely co-tenants. They had received their interest through intestacy and testate transfers, but they are not in possession of the property. And as Your Honor knows, under RPAPL 541, that first 10-year period of adverse possession is deemed possession for
But does
either
the record
co-tenant.
reflect what they're doing all of these years? I mean, if you have a 50% share of the property, basically, I mean, wouldn't you show up in all those years?
Not necessarily, Your Honor, because you do have that statutory provision that provides that is
I
not.
mean, what made them wake up to this in 2022?
Well, Your Honor, they were looking at the deed records and then they realized that there was an issue. They had no reason to before that because all of these transfers that happened were subsequent to their interest in the property vesting. And that's sort of one of the.
Well, I mean, I guess what happened, I thought, was that by 2019, everybody had died from which this new group of people had gotten that. Maybe somebody was looking through the estate and said, "Ooh, I wonder what this is."
That's right, Justice Kapnick. There were a number of deaths, and the chain of title is really not in dispute in terms of how the heirship worked and how the testate transfers.
That's one of the few things that's not right.
But essentially, you're right. These were people who had become vested in title prior to the deed that is in question, this Argentino deed, which is the purported 100% transfer.
So that's where the problem is that Negasar gives 100% interest to Argentino for $25,000.
No, it's the opposite. It's
Right. Argentina gives Negasar 100% interest for $25,000.
He receives it for $25,000. That's one of the reasons, Your Honor, that we feel like there cannot be a claim of right established in this case, especially not on a pre-answer motion to dismiss, because as Your Honor knows from having obviously looked at the transfers, there's a number of quick transfers of this property with varying prices. And these are sophisticated parties, the respondents. They own a number of properties in
Can you address, please, the issue of latches? I mean, it could easily be that at some point, one party, the party that you are claiming under, said to the party that defendants are claiming under, sure, you take the property, give me $5,000. And $5,000 in cash passed one hands from one to the other, and that was that. But the problem is when your clients didn't do anything for more than 20 years, all the people who could have had knowledge of that died. So how do you address the latches argument?
Right. Well, I mean, the laches, doctrine shouldn't supersede the statutory provisions. We talk about 20 years being the statutory period of time that adverse possession would actually ripen. And the key issue on the laches, Judge Scarpula, is notice. All of the case law that talks about laches is you know something, then you sit on your hands and you don't do anything.
Well, you know, somebody knows you have a half interest in a deed that's recorded. You know that you have it. You have plenty of notice. And you do nothing for more than 20 years.
But, Your Honor, that's not what needed to be done. The issues of laches is we're talking about what was done after the putative 100% transfer deed. And there was no notice of that. And even if there were...
Well, wait,
it was filed.
I mean, how is there supposed to be notice? You're claiming that they had to send you notice? I mean,
well, no.
You would think that after 20 years, somebody might have stopped by the property to see what was going on with their property.
That's the exact point, because if somebody did, that's discovery. That's not a pre-answer motion to dismiss, and it certainly isn't clear.
But counsel, let me just ask you, wasn't that deed filed? Wasn't that deed filed?
But, Your Honor,
what more notice could you ask than a public filing saying, I own all this property?
Your Honor, you're essentially going to impose a duty upon property owners to look at subsequent transfers, which is contrary to the Goodwin case, and it would actually make adverse possession easier for people. That flies in the face of all of the legislation.
I don't know that it means you lose, but the idea that for 20 years you just don't show up and say you don't know anything about it, and you don't have notice, every case at the end has to be decided based upon its facts, and it's really like sort of stretches credulity that you can not come around for 20 years and say you know nothing about this for 20 years, and then wake up one fine morning and say, oh, I own half that property.
I understand your point, and facts is the important word that you use, Justice Friedman, because facts are what get discovered during discovery, not on a pre-answer motion to dismiss. If there were some notice, if there was something that could have been done, let's take depositions. Let's have an answer and have a trial. I mean, the idea of ouster alone, that concept, which is the linchpin issue on this appeal, is in the province of the jury. You look at the Perez case that we cited. It's not for a judge on a pre-answer motion to dismiss that says, as a matter of law, this was an ouster. It's completely contrary to the Midland Avenue case, which I cited, which I understand is in the Second Department, but that is a case that is as squarely on the 4 points as I can cite. It's time for this department to follow that logic and say that as a matter of law, a deed from a co-tenant purporting to divest a co-owner of its interest is not, as a matter of law, an ouster.
Okay, thank you. You have rebuttal time.
Good afternoon, Your Honors. Arthur Jacoby of Herrick Feinstein. I represent the...
So Romero's interest comes from Negasar, right?
That
It's
is
dependent upon the fact that Negasar received 100% interest
Correct.
in this property for $25,000. But when you look at the record, there'd be nothing which would show that Negasar was that Argentino was able to give 100% interest, because the record, I presume, there's not contravailing evidence in the record, would show that he only had a 50% interest. And when you consider 5013 of the Real Property Actions Proceedings Law, how does that constitute a reasonable basis for believing you have 100% ownership here?
The Negasar deed was quite a few deeds back when the Romero's, it was 1, 2, 3, 4, 5 deeds back.
That's where your interest comes from, right?
Romero's, correct.
How did nobody, like title insurance, how did no one pick this up after all these years? I mean, when I buy something, they make me go through a million different things. How did nobody pick up this in the title that somebody had 50% and owned 50% and conveyed 100%? I mean,
That is a terrific question. And in most cases, I would figure it out. But in this case, the evidence is 20 years old. The title
More than
agents,
20 years old.
lawyers are retired.
Can I
files
ask
are
you,
just-
people are
Not-
dead.
The record is not 20 years old. The record is still there. Whatever
Yes,
the
but as
the
Judge
recording shows.
Yes,
Right,
but as-
why didn't you put in the title search that was done by your clients? I mean, that would have shown that all you did was put in the chain of title, which, as we know, since 2008, is insufficient. Why not put in the title search that your clients had to have done to get a mortgage on the property as late as 2012 or wherever? I think, or maybe they said 2000. When was the last mortgage they got?
in 2012.
Right? So why not put that in? And why didn't your clients
title searches-
straight up say, we did not have any idea at the time we took the property that there could be a cloud on title, which your clients didn't do? Those
My clients do say that they had no idea.
I
They're
read those two
bona fide
affidavits.
purchasers.
They said, we were shocked. That is not saying at the time that I purchased the property, I had no idea that this was going on, right? So you didn't put in any title searches, which you could have, and you didn't put in straightforward affidavits from your clients.
My clients put in an affidavit.
They did.
saying
I
that they are
read them.
bona fide purchasers of value without notice.
What about the title
That
search?
means that they did not know. They bought the property. They never would have put tens and tens of that. This was a gut renovation. They bought the property, it was uninhabitable. There was one apartment that was still habitable. What they did is for 2 years, from 2004 to 2005, the whole world would have seen this because it was a construction site. And they
Apparently, except the plaintiffs who never came by, but
and the
okay.
plaintiffs never came by. And I would love to go back and be able to prove what happened.
Now, why
But
didn't you
we're-
put in the title search?
the title search because it didn't show anything?
How do you want, okay, that would be nice for us to know, but since it's not in the record, we can't tell that. And that is a document that would have been very, very powerful. And particularly because of the fast transfers for very little money right after the initial I own all the property transfer, right?
Right, they brought up the fast transfers only in connection with briefing this case. It wasn't brought up in the court below. It wasn't mentioned. It wasn't an issue in the court below.
But it is what it, I mean, it's
Came-
not a fact, I mean, these are.
I understand.
It's there.
You're right, Judge. I get it.
Not a fact
Trust
issue.
me.
Right.
We would have addressed it had they brought it up in the court
I mean,
below.
whoever would look at this chain of title will have to see this property sold for $25,000. What property is getting sold for $25,000?
A property that's uninhabitable, a property where you have to redo the roof, you have to redo the facade, you have to put on new doors, you have to put on new windows. Our affidavit demonstrates that they did all that because it wasn't habitable. Those properties go, certainly in 1999, they go for $25,000. And I wish we could go back. I wish I could depose Sandra Del Val is dead. The person she was, her co-partner, Marie Argentino, is dead. Sandra Valdel's immediate heirs, 3 of them, George Del Val is dead. Peter Callegrio
Well,
is
I mean,
Mary-
I know, I read the transcript, and I mean,
How
that is the theme of this, but do you think that that there shouldn't be perhaps some additional discovery to see if we can find out anything other than what you guys have already told us in your papers?
No, because the 2 principal parties who dealt with each other are dead. Both sides are dead. Not only that, bank records are gone. You cannot get bank records from the year 2000. The legal files are clearly gone. They're over 25 years old. They're gone. The title records, the underwriting records are gone. They're over 25 years old. There's no way to go back and put the pieces together. They had 25 years to bring this case. I wish they had brought it. I was practicing 20 years ago. I would have subpoenaed the title file. I would have gone to the banks. I would have deposed the witnesses, and I would have asked them, tell me, why was this transfer? Explain it to me. And I might have gotten an answer that there was a $5,000.
But you didn't do that. That's the problem. This is a pre-answer motion to dismiss, and your clients didn't say, we don't have our title search anymore. They obviously got insurance, so they had to have had a title search, and they got mortgages, so at least in 2012, there had to have been a title search. Your clients don't say, we don't have those documents and we can't get them. All they say is, we bought the property, we renovated it, and then we were really shocked when we found out.
We didn't know, correct.
Right.
But they wouldn't have known because the predecessor in interest was 100% owner. And that predecessor in interest was 100%
The
owner.
title insurance company should have picked it up. Should have picked it up.
Okay,
Come on.
I got it. Thank you, counsel.
Thank you very much.
Just very briefly, to pick up on the title insurance issue, this is exactly the kind of notice that needs to be explored in discovery. I mean, you know, the
Well,
fact...
how do you get around that? I mean, he's saying everybody's dead. Everything's gone.
Well, because, Justice Pitt, just because somebody dies doesn't mean there's necessarily prejudice. You have to show that their testimony would actually tend to support your position. What is important for the court to recognize is the record of the chain of title. That sets forth what the ownership interests were. And
I mean, that's your starting point, right? I mean, listening to the arguments here, your starting point is the chain of title and the title search. You got to nail that down, because anything else, if that shows a problem, okay, then you may get, if you may be going forward, you know, if we agree with you. But if it doesn't show a problem, I think the defendants may prevail, right? I mean, right?
I mean, did you even try to get did you try to get the title searches? Did you look back on any title searches that may have been available?
No, I mean, if that would have been something that if we had to subpoena the title insurance company during the discovery, we certainly would have. I mean, these are all issues that need to be fleshed out in discovery. It's entirely too premature to divest these individuals of their interest in real estate. You know, because, you know, the prejudice to the other side is a title claim. You know, we're going to have their opportunity. If they ultimately are successful at trial, that, you know, that's to be determined. But we need to at least have an opportunity to be able to take depositions, to subpoena documents, and to be able to try the case. Thank you.
Okay, thanks
Appreciate
very
it.
much. Thank you. Thank you. Gorin versus 72A Realty. Go ahead, counsel.
Good afternoon. May it please the court, my name is Stephen Sperber, and I'm here for the appellant. This appeal is from a pre-answer motion to dismiss, where in the court below, found that, quote, "the documentary evidence adequately records a proper apartment deregulation in December of 2020. This is simply not the law because at the time, there was a J51 in effect. And secondarily, even if that was not the case, on a 3211 motion, there was consideration of IAI improvements that were challenged as being repairs versus improvements. The law has always been that you cannot deregulate a rent-stabilized apartment while receiving a J51 benefit. In fact, Justice Carpulli, you were on a panel just last year that was quite instructive in trying to teach members of the bar how we analyze these issues. It's quite complex. But Roberts was not a change. What it was a clarification of a mistake by the
Well,
agency.
DHCR had been interpreting the law incorrectly for a
Absolutely.
long time.
Absolutely.
I don't think they would, I don't know if they do it intentionally, but that's how they interpreted the law until the Court of Appeals said, oh, you guys are wrong, and that's when things change. But wasn't there a certain limitation? I mean, the way they did it was understandable at that time, because that's what DHCR said. But because there was such a long period of time, this apartment was deregulated in 2000. And they did it correctly. I mean, there was no indication that they didn't do it correctly. So now, even by the time Gersten decided it was retroactive, wasn't that just too long for anything to be changed?
No, because in
that's what
2009,
the
Roberts
cases-
said, nope, you were wrong on the law. And in 2011, Gersten said, and it goes all the way back, so you have to fix your records and you have to
Only
register.
by 4 years, though, right? The look-back period was only 4 years.
The look back is 4 years on a rent overcharge. There's 2 points here, though. The first one is coverage, Judge, and that's the more important point. Is my client rent stabilized? And if she's rent stabilized, then whether or not there's an overcharge, that's something that could be fleshed out below, as you would only go back after the Court of Appeals decision in 19, you would only go back 4 years from when we filed to 17. I agree. And probably our rent overcharge case wouldn't be that strong because of that. But our coverage case, I happen to be on the wrong end of Taylor and Ryan, which is cited in our brief. And in that case, I represented the landlord, and the court said, no, on a coverage issue, you can go all the way back. And that's exactly what the law is today. The landlord argues at page 19 of their brief, the validity of deregulation must be defined by the law then in effect. Well, Gerstein tells us that the law then in effect is you can't deregulate a J51 apartment.
No, but the apartment came out of J51 before Roberts, and then so that it would have been deregulated even without the J51.
If they deregulated it, and I
But we have
to
case
say,
law that says that that's perfectly okay.
there's a lot of case law that says that they had to do the deregulation, and they didn't do that.
No,
And
we have a case directly on point that says that if they were entitled to deregulate after they came out of J51 and before Roberts, then they're good.
but that on a 3211.
Isn't that what we're dealing with right now?
No, not really, Judge.
I mean, your
because-
client came in 2020
Yes.
and had no idea about any of this, right?
correct.
Because and then now your client is saying, not only am I entitled to go back till 2004 and deregulate the case, that's what you're asking us to do here, right?
Yeah.
Okay, even though we have case law that says that if they improperly deregulated during the J51, but then after the J51 was expired and before Roberts, they had fulfilled all the requirements, then it's deregulated. That's what our case law says. Do we not agree on that?
Well, we agree in part, but we also have to consider that this is a 3211 motion, much like the case prior. And in the case at bar, if you look at page 153 of the record, they're claiming that the increase of the rent from $1,099 to over $2,000 is based on a renovation of the apartment. Now, it's not in an affidavit form, but what the contractor says in a letter is, I did all of these things in renovating the apartment. And he includes, I repaired, plastered, primed, and painted wall damage caused by removal of baseboards. I repaired all ceilings, installing sheetrock where necessary, and I primed and painted. I primed and painted and repaired bathroom walls with Benjamin Moore high-gloss paint. Those, Your Honor, are not improvements, capital improvements. Those are basic repairs. And on a 3211, at the very least, I'm entitled to the court to give me a favorable inference. And without looking at deposing the contractor that did that work and going through this without discovery, I can't do that.
All right, well, what about the complete kitchen? I mean, what you're saying is maybe a couple of things didn't carry, but there's a complete kitchen renovation. There's plenty of evidence there that you haven't disputed.
I can't dispute it.
Right, exactly. So
can't-
what
I
are you,
can't
so
turn
then
back the
what are
clock.
we talking about here? You're picking up the painting as if that's going to change the result. But there was a big renovation there that you cannot dispute. And you're picking out two little things and saying, for that reason, let me show you actual fraud?
I don't need fraud. This is
Yes, you do.
No, most respectfully, Judge, I don't need fraud because this is a coverage issue. On an overcharge, if I want to go back and say there's an overcharge, then I need fraud. But all I'm saying is this is a coverage issue, and I can go back.
Having moved in 2020, why won't the 4-year look-back limitation preclude relief for you?
The 4-year limitation, Judge, relates to the rent overcharge issue. But again, the other issue is the coverage issue, whether or not she's entitled to remain, whether it be at the $4,000 rent or at the lower
What's the
rent.
case you're relying on for that? Ryan, you said?
Well, Taylor and Ryan, yeah, is one of the cases.
Taylor.
Yeah.
Got it. Thank you.
And most respectfully, Judge Gersten says the same thing.
Okay, thank you.
Good afternoon, Your Honor. My name is Joel Zinberg. I'm appearing for the defendant respondent, 72A Realty.
Can you address the issue that your friend over here has relied upon, that there's a distinction on the law as to coverage as opposed to the rent overcharges?
Well, the problem is that he's completely ignoring the facts in this case, facts that are undisputed. They were provided in rental histories that are in the record that they have never contested. Those are available in Exhibits F and Exhibit M in the record. The record shows that the J51 expired shortly after the apartment was deregulated in reliance on
Like
the
around
DHCR.
2003 or something like that? in
Correct,
that neighborhood?
2002, 2003. And there were 8 tenants who followed thereafter. All of those tenants came in with rents above the threshold for deregulation. They were all these were all vacancies that were deregulated by operation of law. We cite multiple cases that support that proposition. My learned opponent doesn't cite a single one that contradicts that. Every case he cites talks about instances.
It's in 2012. It's in 2012, is it not, that the law emerges that you should have been re-registered because you were getting J51 benefits?
Correct. Gersten is the appeal from Gersten is withdrawn that year. But at that point, there had been, I think it was 4 or 5 tenants, all free market tenants, all legitimately free market tenants.
And counsel,
you could not go back. As we document in the brief, the DHCR wouldn't have even accepted a re-registration. There would have been no point in re-registering an apartment that had been.
Counsel,
sorry, Your
just so I can understand, and that is because every time a new tenant moved in, the rent went up based upon the vacancy.
Correct. Well, first of all, Your Honor, it had already exceeded the 2,000 threshold in 2000 on the basis of the IAIs. Right. But we also document that even if you don't consider the IAIs at all,
right?
Again, in calculations undisputed by our opponents, that the rent would have exceeded the 2000 deregulation threshold in 2007. And as this court said in the Breen case, you can do that sort of calculation and show that it was susceptible and would have been deregulated.
So your position, counsel, is that even if we subtract the painting, that the IAIs would not carry the day because vacancy increases would have brought it to over $2,000 prior to Roberts, and that that deregulation would have happened by operation of law,
Correct, Your Honor.
and therefore, okay.
Our position is that you don't need to consider the IA. However, I do think the court below got it exactly right. When you do a gut renovation, which is what the court below did it after a lengthy recitation of all the documents, and as the contractor from 24 years ago himself said,
That was a
total
miracle that
renovation.
you found those documents.
That's
Better than the last case.
Yeah, but we never get that.
correct. So when you do a total renovation and you pull out walls and you pull out windowsills and window boxes, you're going to have to repair around that. You're going to have to paint.
You have to paint.
That's part and parcel of a total renovation. And cherry picking those words is an attempt to mislead the court. So both on the basis of the IAIs, but even without the IAIs. So there's absolutely no reason to reverse the court below. There's no reason to go back. There's no reason that the appellants need discovery or a trial.
Even if in 2012 you should have then corrected the registration status, but certainly in 2020 you can't go back to 2012 to try to affect your 2020 situation.
I'm not sure what Your Honor is asking.
In 2012, it comes out that you should have registered, right?
No,
In 2012, it comes out that the deregulation in 2000, while the J51 was in effect, would not have taken place.
And then when you became, it was ineffective, so you should have continued to be registered. But it then emerges that no matter what, you're entitled to be deregulated.
Correct. The apartment was entitled to be deregulated at the latest in 2004 because that's when the next vacancy deregulation occurs with the rent above the threshold.
And when did the J51 end?
It expired in 2002.
2002.
Yes.
So, right. So we're talking 10 years of before Roberts.
Correct, Your Honor.
And at least, okay.
And the prospect
And in 2020, there's no basis for you to go back. If there is, you're limited to 4 years, and if you go back for the 4 years, you were deregulated.
Correct. If you go back to 2004, we were if you go back 16 years, we were deregulated.
You don't need to get so far back for this case.
Okay, but all I'm saying is it was pretty clear we were deregulated. And I might add, by the way, Your Honor, that going back to look at, do a trial and try to resurrect, and I do mean resurrect, people from 24 years ago, because many of the principals I know are deceased, and many others I don't know, but probably
Seems to
are
be the
deceased.
theme of today.
Is precisely why we should not be sending this case back, particularly when 72A has provided a complete record of the renovations, all the leases, the entire rental history, and undisputed calculations.
Okay, thank you.
Just two brief points. Firstly, in 150 East 3rd against Ryan, the case that I spoke of before, it was held that the tenant should be able to challenge the deregulated status of an apartment at any time during the tenancy. And that was over a decade after deregulation. Upon such challenge, consideration of events beyond the 4-year period is permissible if done not for the purpose of an overcharge, but rather for determining rent regulation status.
Right, meaning that if there was fraud in deregulating, that's what that means.
Most respectfully, Judge.
Or let's say deregulation when the J51 was going on that didn't otherwise get didn't otherwise change. Let me just ask you one thing, Mrs. Berber. You know, these cases are so complicated and hard. What is it that you think you're going to find in discovery?
I think that I'm going to find that they didn't get over the threshold, they should have registered, and that she's rent stabilized. And while I might not get an overcharge, at least she gets to stay in the home that she has. And if I may just leave you with one parting thought. At page 20 of the respondent's brief, it says as follows. Once the J51 expired in 2023, the apartment reverts to the prior status. I agree, and I ask Your Honors to agree, because once you agree, then it's rent stabilized, because in 2000, there was a J51 in effect. That's exactly what they wrote in their brief, and that's what I'm asking Your Honors.
But counsel, the difference is here, the J51 ended in 2002. And during that period of time, they could have, and by operation of law, counsel is arguing, it was deregulated.
Well, this
And we have case law.
operation of law deregulation is a foreign concept to what I see, but could have, you left out most respectfully the words should have. Thank you.
Thank you, counsel. Okay, Mayville Engineering versus Peloton. Look, we cleared out the courtroom for you folks. Look at that.
Thank you, Your Honor.
Oh, don't thank us yet. Wait till after the argument.
Good afternoon, and may it please the court. Mark Gimbel of Covington and Burling on behalf of appellant respondent Peloton. This appeal arises out of a supply agreement between Peloton and MEC, a large...
Why isn't this contract subject to, because as the court below made it very clear to the movement, your client attorney, you got to demonstrate as a matter of law that your interpretation of this contract is locked down solid, that I don't have to pay a dime if I don't put in any purchase orders, period. And the court below says, I don't see it because it's plausible that their interpretation of minimum requirements in terms of the revenues and the columns, Exhibit A, that's plausible. So why is it that, you know, she got it wrong?
Well, in determining whether a contract is ambiguous, you got to look at the contract as a whole.
You know what? It's interesting. The Supreme Court, the justice never said once that it was ambiguous. She just said, I got two versions in front of me. I got to figure out which one is the correct interpretation.
She did, Your Honor, say on the transcript, I don't know who is right and
I've
who
looked
is
it up. There were
wrong.
two words ambiguous, but that was talking about something else. She didn't say the contract was ambiguous. I
Well,
looked it up, though.
Respectfully, Your Honor, I think you have to look at it. A contract has to be read as a whole.
Yeah.
Right? And if you look at
my
the
$44 million,
totality-
did you see my $44 million decision? I had to read the contract as a whole, right?
Right, and if you read this contract as a whole, there are numerous provisions that are just simply inconsistent with the obligation.
Pick one.
Suggests. All right, start with the most obvious, payment terms, Section 5.3. Right. It's the only payment term provision in the contract, and it doesn't
refers to
mention-
Exhibit A.
Huh?
Doesn't it refer to Exhibit A?
It doesn't. Section 5.3 does not refer to Exhibit A, and it
But
doesn't impose a
5.2
minimum
does.
payment obligation.
But 5.2 does, and why on Exhibit A are there amounts filled in where there's zero average per day? I mean, you have again and again, 11 times that there's zero average per day, and there still is average fixed revenue, average monthly fixed. Why in the world would you have that if your interpretation of this agreement is the correct one?
Well, let me start with 5.2, since Your Honor started there. What 5.2 says is volume-based pricing agreement, right? So it's setting up a pricing model, and it says the parties will implement a volume-based pricing model that accounts for the capital investment and fixed cost expense that supplier will undertake, right? And the key word here is pricing, right? It mentions the capital investment and fixed cost that MEC is going to undertake, but it doesn't say that's going to be covered by a minimum revenue guarantee. It says it's going to be accounted for in the pricing.
Right, but
Pricing
then
model.
then it references Exhibit A, which does have these minimums inside there.
Well, and when you look at Exhibit A, what it is a pricing chart, and it sets out at different volumes what the price of a part is going to be.
But it makes a provision of if there's nothing, is zero. I mean, it seemed weird, but it's on all the different pages and all the different parts, the possibility that they might request zero, and there's still a price next to us. So that's the thing that, on every single page, that's part of Exhibit A, and I don't understand how to explain that if it's not, well, if you don't order any parts, you still have to pay a basic minimum.
So what Exhibit A is a pricing model. And
Right.
Your Honor is quite right that there's a zero line at the beginning of that model. There's no price associated with that line. The only
But when
price
you said
is...
could you explain that? Because let's just take one, for example, on page 85.
Yeah.
Why on the first line, the zero line, total annual revenue, 598,546. And it goes up on the next lines, obviously, as there are more sales. But why would there be any amount filled in for the zero line?
Because what this is a model, and it's showing you the components of what are used to set a price. One of those components was the amount of revenue that.
What do you mean by model? It's incorporated into the agreement. It's a schedule that its terms are incorporated. A model is, to me, seems like, oh, this could be or couldn't be. That's not this. This is a schedule that is incorporated directly into the agreement. So it's not a up in the air amorphous, this could happen, this could happen. It's a term of the agreement. So let's not call it a model, and explain again. I mean, I still haven't heard, how could it be one of the terms of the agreement is if I don't buy anything, I still have to pay?
Well, Your Honor, I use the term model only because that's what the agreement says. But I stipulate that it is part of this contract.
What the agreement says.
So section 5.2 talks about it as a pricing model.
That's incorporated into the agreement.
Right, and I don't
so
dispute that this schedule is part of
that
that.
accounts for the capital investment and fixed cost expense the supplier will undertake.
Right.
So that sort of fits into what they say about this.
Well, except that it accounts for it, according to the language of 5.2, in a very specific way, by setting a price. So what that is saying is if you purchase a product, that price is going to be enough to compensate them for the fixed cost expense. But outside of pricing, there's no cost.
Let me get back to the first question. Why is there a total annual revenue filled in on the zero line of $598,546?
Because again, it's an explanatory model. It's showing you the components that then get fed through the model. And if you look at
but you're saying that if the zero sold, the zero paid. So why does the model show something being paid when the zero sold?
It actually doesn't show a price. It shows that revenue amount, right, that gets then fed into the model.
It shows revenue. Revenue isn't them paying Peloton, it's Peloton paying them.
Well, it's the revenue that they had to collect through the model.
So let me ask you a related question. Is it not correct that the only items in that Schedule A that have monies being paid for zero product purchased are models or parts that Peloton was required to manufacture itself as opposed to buying from another source and reselling to you? It's a yes or no. Is that correct?
Yes, mech.
So you're saying to me, you're telling us that there's no possibility and there's nothing ambiguous about the fact that the only items on Schedule A that have you will pay whether you buy zero are the items that the plaintiff was required to ramp up and build its factory to produce? You think that's a coincidence?
Your Honor, respectfully, it doesn't say anyone will pay at this level.
I'm just asking whether you think that's a coincidence.
What I think, Your Honor, is that they set forth a pricing model that was to be used when you placed a purchase order. And if you look at the totality of this agreement, it's a purchase order-based agreement. And that's why 5.2 refers to payment.
I can't help but think about what you just said. You know who's going to be able to tell us the answers? The guys who actually drafted these agreements. They were negotiating this agreement, right? I mean, you're telling me this. I don't have anything from the drafters, right? I mean, there was a point made at our argument by the plaintiff saying, we have all the people that negotiated this deal. They don't have anybody. They all walked. They're all gone. So you're going to have a problem trying to prove that point, right?
Well, I think if you look at the totality of the agreement, that's where it goes. And
I'm looking at the totality of the agreement.
Yeah.
It's not implausible, their interpretations. I mean, I would agree with you. If it's implausible,
let me give you two other reasons why it's implausible. First, their interpretation conflicts with the very carefully limited expense reimbursement provisions of the contract, right? Mm-hmm. So I'll just give you one example of those. Section 8.3. It says that they get reimbursed for tooling and manufacturing expenses only if they get a reimbursement authorization, they submit documentation, They jump through all these hoops. Now, you wouldn't have them jump through all these hoops if they were separately and unconditionally being paid for the same expenses. It makes no sense at all. So that's number one. Number two, and I think this is very, very important, is that if you're going to have a minimum monthly payment obligation in a long-term contract, the most basic thing you need to do is specify when that obligation starts. And that is utterly missing from this agreement. They say it started in 2022, about 10 months into the contract, and that January of 2022, and then it kicked in to a further level in April 2022. They've completely invented that.
Well,
It
how about
exists nowhere in the agreement.
Supreme Court's comment? And I never thought the answer was I never thought that her question was answered. The termination provision. Why have a termination provision in there if you didn't have to pay anything?
Yeah, well, so
And I kept looking for the answer. I kept reading and reading, and
sure,
it was never answered.
let me offer you 2 points on termination.
Got that chance now. I'm going to hold you to answering that question.
Okay, so number one, right, our interpretation does not render the termination provision meaningless because it continues to protect both parties, right? So one protection that it offers is that if Peloton terminates, then it still has to pay under the survival provisions for any outstanding purchase orders. So that's an independent
No, because you can't, that's not something you have to provide for in a termination agreement. If you buy product, you have to pay for it. You don't need a termination agreement for that. So it can't be that.
Number
What's
two.
your other thing?
Go
Okay,
to number two.
Number two, actually what is absurd is if you read the termination provision in light of their interpretation, let me tell you why, okay? The termination provisions say, in the survival provision, 21.5, that section 5.2, which is what they're relying on here, survives any termination of this agreement for any reason, including a material breach. So under their theory, if they breach this agreement in month one, a material breach, Peloton, under that termination provision, would continue to owe them $107 million. That is an absurdity by definition.
That might be, but that doesn't mean that the agreement doesn't say what the plaintiff says, which is over a 5-year period, you have the obligation to pay for these numbers for these type of parts, whether or not you buy them. That's, I mean, the other thing, that's not what we're talking about, right? And the one thing that you've said about the termination agreement would be true if you just bought parts and they invoiced you and you didn't pay, you'd still be responsible. You don't need a termination provision for that.
Well, it's
I have to ask you. I know the red light's on, so I'm gonna.
Okay, we'll get it on rebuttal then. Are you going to ask the question? You can think about it. How's that?
I have to ask you the discovery question.
Oh, okay. All right, we'll get that. All right. Thank you, counsel.
Good afternoon, Your Honors. Peter Wang and my partner Susan Schwartz for Mayville Engineering.
Counsel.
One question at a time.
Your position that there's supposed to be this big payment to you no matter what, I mean, wouldn't you expect it would say it clearly in the agreement?
And Judge, that's actually exactly what I was going to start with. What this is boiling down to is the argument that we could have said it differently. I guess that's true with most countries.
No, that's not just that.
Well, say it at all, really.
No, we do say it all. You look at that Exhibit A, and it has a 0 line, and it says, here's how much you pay for fixed revenue, which is exactly what Section 5.2 says.
When it talks about payment terms, it talks about shipping of product, and unless customer rejects the shipment, and then you're supposed to pay. It doesn't, there's no mention here of that there's a payment no matter what.
And then additionally, with the purchase orders, right, that's how the orders are placed. They submit a purchase order, and in sections 2 and 3, it goes through that.
No, actually, Your Honor, that's not what it says. In Section 5.2, it says, we recognize, well, let me back up for a second. We all know how this all emerged. The pandemic came, everyone was locked up, we remember it well. People were buying exercise bikes.
There'd be a million exercise machines.
That's right. People were buying exercise.
And then the market fizzled.
People were buying exercise bikes like hotcakes, and life was good. And these folks understood that they had a problem because the supply chain. This is all in the complaint.
Right.
This is all in the complaint.
You had the domestic suppliers. Yeah, we know.
Exactly. So they needed a domestic supply, and they knew. And they went out and they got it from Mayville, my client. And if life was good and if life continued the way they thought it was going to continue, we'd be sitting here. exercise bikes were still being sold, but that's not what happened. A couple of years later, gyms opened up. Boom, the market cratered. Heads rolled at Peloton, and they decided that they weren't going to do that anymore. They completely abandoned that thing. And meanwhile, Mayville, who had invested tens of millions of dollars.
So if that is true, why not protect yourself the way that you should have?
We did, Justice Garpour.
By putting in some numbers in a schedule? I mean,
Exactly,
I'm not gonna-
because-
I mean, maybe it's plausible. I have a hard time believing that a big company with sophisticated lawyers would protect themselves by putting in a couple of numbers in one schedule in a document.
A couple of answers to that. First of all, what's proceeded here over the last year plus is discovery. Those of you who are on the commercial, the cases continue.
We can't hear that, though. We can't hear what you're talking. We're just talking
No,
about
I'm not
preemptive
talking about
motion
the
to
discovery that
dismiss.
happened, but there's been discovery. That will all emerge as to what that happened. And it will come back, and I predict that in some months from now, we'll be back here on summary judgment, and we'll be talking and hopefully sitting in the same seats as we're sitting here now. That's how this case, all of us,
We're
Your Honor.
banging,
Yes,
we're all
all of
knocking,
us.
everyone knock on wood for that.
Poo-poo. But that's the way the case will proceed, because it's certainly, not only is it plausible, Justice Schechter wasn't buying it. I mean, and Justice
doesn't
Owen is
that
correct. She
argument-
never
why-
said it was
Counsel,
ambiguous.
Counsel, why doesn't that argument work against you, right? You were aware that there's this pandemic, that Peloton needed these parts. You're going to do whatever, you're going to say whatever it is in order to get their business.
No.
Right? But as a sophisticated party, you didn't write into the contract, we get paid no matter what.
No, Your Honor, because the one thing we certainly weren't going to do, because we weren't born yesterday, we were not going to invest $100 million for a pig in a poke. And so we protected ourselves specifically by saying that this demand is going to be dynamic, changing, and look at Exhibit A, part of the contract, and it will tell you for each amount how much you're going to pay for fixed revenue.
I guess what my colleague was saying was it might have been better in hindsight, which things are always better in hindsight, if there was a specific section that said we are intend to invest X amount, and so we should get paid no matter what, written clearly. Instead, we have to try to figure it out by looking at the contract and the pieces together and say, look, all together, this is what makes sense.
And to add on that, such a glaring situation where you have zero and there's a money and there's a dollar figure assigned to that. Somebody's got to look. Somebody didn't proofread that line. That's about it, right? I mean, if you saw zero and you saw like a lot of money, wait a minute, what's going on here?
Well, not really, Your Honor, because again, that a lot of money is for fixed revenue. There's other columns for variable revenue, meaning how many you buy. The Justice Scarpula had talked to my friend about the first exhibit, which had to do with parts that we were buying from third parties. The zero line has nothing, because that makes sense. That's what they were trying to protect.
But let me ask you this. Let me switch gears for a second and talk about discovery, because I wonder how you can say that the defendant is not entitled to at least see what your fixed costs were, because you're bandying about numbers now. I don't know that your fixed costs weren't $10, which would make your view of the contract very suspect. So I can't imagine that in our broad discovery state, the defendants can't even get numbers of your fixed costs.
In fact, there has been substantial discovery with respect to fixed costs.
Okay, but we
You
have a denial of that,
you have that other
right?
appeal where Justice Schechter drew a line and said what you can't, which I think was
Well, fixed costs is one thing she said you couldn't get, they couldn't get.
in
So
the context.
I'm asking you to justify that.
But because in the context of what they were asking and when they were asking, because again, subsequently they filed a counterclaim, and there's been broadened discovery that includes things like costs. They were trying to do it, I think, in terms of mitigation, and what Justice Schechter says, this has nothing to do with mitigation. This is a line item that says, here's the amount you pay for fixed costs, so you don't have to, it's a liquidated amount.
If you were able to sell whatever you were supposed, and I'm sure it's not so because they were Peloton parts, but if you were able to sell all of those parts to someone else so that really you suffered no loss, wouldn't that also create suspicion about your interpretation?
No, I don't think it's about the interpretation of the contract. That may be a question with respect to mitigation, as to what the damages
So
are.
why shouldn't that come out?
because it wouldn't be necessarily what the fixed costs would be, what we did versus what the damages are. In other words, we have a liquidated amount, and if they're entitled to.
But we're
try to
talking
show
about
mitigation,
discovery, right? They're entitled to show mitigation. Why shouldn't they see whatever you've got to show that that you were able to mitigate? Mitigation is always relevant.
And Your Honor, and again,
Okay.
Subsequent,
You fixed it?
Right.
Well, I'll ask your
I was going to say that as a
You
practical
may not
matter.
get admitted at trial if there's a trial, but in terms of discovery, they're not getting the answers to those questions.
Again, Your Honor, I think that this is at the time that this appeal was filed, many things have happened since then. I don't think it's appropriate for us to.
No, that's fine.
To talk about that.
It would have been easier if you stick to it, then we don't have this issue. But okay.
I just have to do just one other thing, Judge, if you'll
Okay,
allow me. Only because the one thing that struck me, many things that struck me, this case has not one remarkable case citation in both briefs. I don't remember the last time I cited Lucy Lady Duff Gordon. I was getting flashbacks to law school that we're citing 100-year-old cases for contract interpretation. But what I had to do, and when I saw the panelists, I said, I'll bet you that you ruled on motions to dismiss. They came up here. I found a case. We added it to our additional citations where Justice
Thank you.
Hoying,
I know, I got affirmed. Felt nice.
and you were affirmed, and it was precisely the situation, finding that, this wasn't the most wonderfully written contract. People could have said it differently, but it went and it was affirmed. That's what should happen here, Your Honor. I'll speak on the reply with respect to our cross appeal.
You got it. Thank you.
Just very briefly, a couple of points. First, Justice Scarpula, to pick up on discovery, it's relevant to two issues.
I know why it's relevant. I just want to know, is it fixed? Are you going to stipulate
No, we don't
to it?
believe
All
that
right.
the
Okay.
situation
That's
has
all.
been fixed. On the merits, there's a lot of table pounding in the briefs in the argument about all of the money that MEC had to spend to supposedly prepare to perform this contract for Peloton. The easy answer, I think, to that argument is that contracts are interpreted in accordance with their terms. And despite, all of MEC's complaints about what it supposedly invested, manufacturers invest capital to build capacity all the time. That's their business as a contract manufacturer.
Did they? No, but they're arguing they built something just for you, for Peloton parts, not for general widgets, but for you. And in fact, it would support their view if they did spend $100 million on creating a facility, and it might support your view if they spent $50 grand upgrading a couple of their.
And that's why we would need discovery if
Yes,
this got sent
100%.
down.
Got it.
But the one thing I'll say is, you said they built something just for us. In this business, what that's called is tooling. That's the customized machinery. And the contract is clear about who pays for tooling. It's MEC, unless it gets a reimbursement.
So quickly, why don't you talk about the implied covenant of good faith that Supreme Court dismissed?
Yeah.
Because that's going to come.
Sure. Your Honor, I think that the claim was quite properly dismissed because it is inconsistent with the express terms of the agreement. So their implied covenant theory is, you owe us $50 million or whatever it is because we supposedly invested that and you didn't place any orders. Well, the contract gives us the right not to place any orders. That's in 4.1. And the contract very carefully limits when they can recover expenses.
Everything's in the contract. All within the four corners of the contract, you have your remedies.
Which we're trying to figure out.
Which we're trying to figure out.
Right.
The implied duty of good faith and fair dealing. Where's that coming from, right?
It doesn't come into play because expense reimbursement is very specifically dealt with in Section 8.3 and also in Exhibit B. Finally, Your Honor, just to close here for a moment, I think what is unreasonable here is not Peloton's interpretation of the contract, but MEC's. Because what MEC posits is that two sophisticated parties, both of them public companies, spent the better part of a year negotiating a contract with highly detailed payment and expense reimbursement provisions and failed to include a single sentence in the body of the contract addressing what they say is the largest obligation of all, $107 million revenue guarantee. That argument is just totally implausible. It's inconsistent with the totality of the agreement, and that is just not how sophisticated parties document nine-figure obligations.
Right.
Thank you.
Thank you.
I'm the only thing standing between you and recess, so I'll try to be very.
Don't worry.
Don't worry about it. We're way ahead schedule.
Your Honors,
I run a tight ship.
we haven't heard a word about what the zero line means. Why is it there? I understand that we have a difference of opinion about whether or not it could have been stated differently. Not
No,
necessarily
no,
better.
that's not quite the argument. The argument is a $107 million obligation, if it was intended, would have been set forth expressly in the agreement.
And we say, Your Honor, that it was. That's what the zero
By
line
a
does.
zero in a
Well, I'll put
schedule
it-
with no other context or statement.
In an exhibit.
Well, no, but the exhibit is clearly part of the contract.
yes.
Again, I'll put it a different way.
Not exactly the most commercially reasonable.
And that's exactly what Justice
Plausible.
Oing found
But
in his
plausible,
case
I
when he said
guess.
it wasn't a model of clarity, but that's
Yes.
what. But here's the difference, if you will. We say, we look at the contract and it says, here's what it says: zero, fixed revenue, pay it. They say, here's what it means. That's the difference between us. And on that level,
So spend a little time on your implied covenant
yes,
of good faith and
yes, Your
fair
Honor.
dealing.
Okay, I think Justice Schechter, frankly, was so convinced of where we were on the contract claim that she says, well, we don't have to fill in any gaps here because the contract deals with it. On a motion to dismiss stage, life is long, and we certainly have an alternative claim to these tens of millions of dollars of cost we went, if it turns out that...
In what way do you have a good faith? How did they perform the contract in bad faith?
Because if we show that we were induced to pay these tens of millions of dollars on, and again, I don't believe it's ambiguous or anything like that, and ultimately some fact finder finds that that's not what it means and there's no reimbursement obligation for these fixed revenues, we should be entitled to show that
The fixed revenues, which are not in there. So that, I don't see that.
Well, the fixed revenues aren't in there, Your Honor.
If
Our
the
point...
contract goes the way that the defendant says it should be read, they performed. You performed and you're out. And you had the risk. That's not bad faith. That is just not bad faith. It's, I performed under the...
Bad contract drafting, but not bad faith, right?
And on behalf of litigators everywhere, that's what keeps us in business.
You made a deal helping to sell a lot of product, and it didn't work out that way.
But as Your Honor said, our only point is that the dismissal of that was premature at the motion stage, not ultimately. I mean, the whole focus of this case obviously has been on the contract.
Surprised you didn't plead an unjust enrichment claim, if you're going to argue that.
Except that, well, not to argue against that, Your Honor, but number one, the court did say that it was dismissed with prejudice.
Yeah.
So we would be able to replead that. Second of all, there might be a question as to how they were enriched by it, as opposed to us being induced to pay.
Well, thank you very much. This was a
Thank you,
good
Your Honor.
argument. Thank you very much. All right, folks. Have a good afternoon.